This is Dan Bell with PatentLawyerCLE.com. We're offering a complete California patent law course I would like to show to you. You come here, you click California, and this page comes up here. You can read about the course, and there's video to watch. And if you make the decision to go ahead and sign up, you click register and enroll here. It'll take you through a process to register and enroll. If you have any trouble with that, or even before, if you want to, you can click how to register here and watch a video. But once you're enrolled, you'll land here, and this is the course web page that you'll end up at. I'm going to move quickly because I just want to give you an idea what the course is about. This top video is a short video that shows you how to get CLE credit, which mainly means you watch each of the videos. And as you watch the video, in the last 10 or 15 minutes of the video, there'll be a code on the screen that's shown and said verbally. And so you write that down, and then after you've watched the video, you can do it, for example, right away if you want to. You put the code in here, check it for hour 1, and then go watch the next hour, and then come back and check it for hour 2. And then when you're all done, you click next here, and then that's what this is, submit all and finish, you're done. And at that point you can come here and get your California certificate, and you can also give feedback if you want. That's what these other items are. There's 25 1-hour videos. The first 12 are discussing a book. I should say for CLE credit, all you need to do is put in those verification codes I showed you. But the videos will be discussing a book, and the book, Legal Process Design, Patent Invalidity and Infringement Analysis, and we'll cover the first 2 courses in this book. There's 4 courses. The first course is Priority Law. The second course is Specification Maps. And those are the first 2 steps you do for an invalidity analysis. And the book also includes a reference chart process, which is a process you perform to find references to invalidate a patent. And then there's an infringement process. This is the final process in the book. This course covers the first 2, Priority Law and the Specification Map course. So that's what these hours are. They cover the first 2 parts of the book. The first 12 hours are, there's, I believe, 4 hours. Let's see, section 2 is 15 through 19, and then 20 through 25 are ethics-related, substance detection and abuse, summary of the ABA changes to the model rules, ethics of outsourcing, websites and social media, and elimination of race and gender bias in the legal profession. For each of these ethical 1-hour videos, there's material right below the video to read along if you want, or to follow, or to keep, or refer to later. Those are for you to keep. The first 2 parts before the ethics, book 1 is for the priority law here, and book 2 is for the specification map process. Let's peek. So now I'm going to show you the book that the videos talk about. There are questions at the end of each chapter, but it's not your job to answer those questions. This book would be if you wanted to use the book to build a team and scale a team on invalidity and infringement analysis. It sets up what I call a legal process design. So I just wanted to, I'm going to kind of rush through this just so you're going to get an idea of what this is, but I just wanted to cover a few main points. So the structure of the book, this book that we're looking at now on the screen, is there's a priority law course which is used, it's a concept. Priority law is used throughout patent law, and so it's a context for these other 2 major processes, invalidity analysis and infringement analysis. The priority law tells you whether or not something's prior art to a claim, and whether or not an infringing embodiment is infringing or early enough in time to be prior art, and that's why we use priority law. The invalidity analysis course has 2 courses in this book that are taught. The spec map course, that's where you map the claims against the specification and look for problems with the spec or the claims, or section 101. We'll look at those in a minute. And the reference chart is where you take the references you found and you make a determination whether the claims are obvious over a reference, which one or more references, or anticipated. And that's what the reference chart, of course, is. The infringement chart course, which is the 4th course in the series, which is not included in this California training that we're showing you right now. Neither the reference chart nor the infringement chart are included in it. Just the first 2 are priority law and spec map. But infringement chart process is searching for evidence of use of a claimed embodiment and mapping the proof of or the evidence of use of the claim language in the commercial embodiment into a claim chart. And so that's what the infringement chart course is. And these are actually each of these courses really are a life of study, and so we're going at them, if you will, at sort of a medium level of abstraction, and it is best shown by example, I suppose. After reviewing some of the main ideas in that introductory area that we just finished looking at, which is about 18 pages, we move on to the first course, the priority law process or course. The priority law course is both the process documents to provide and create the work product, and it's also the training materials to teach someone what the process is and how it works. And so, but what I'd like to do first is skip to the bottom and show you what the process looks like done, and then I'll go back up and look at it. You can see a couple of chapters to see how we develop the process documents. So I'm going to scroll down now. So you can see we've jumped ahead to page 173 here at the priority law process documents. What we did in those first 172 pages is develop the theoretical underpinnings for these process documents and how to populate and use them. And so someone who is working with this package, if you will, that I'm calling the priority law process, once they've been through the course and completed those chapters and the questions and possibly tested out on the materials, they then would begin performing the process under the supervision of an expert patent lawyer, and making sure that they understood and were able to apply the concepts. Let's go ahead and look at these process documents now, and then we'll go back up and look at how we develop them. The priority law process starts out with a flow chart, and in the end, what the priority law process is asking is, in the main concept, is is this patent valid? And in order to do that, you have to determine what the search dates are for claims. Then you search for prior art, and then you find out whether or not the patent's valid over 112 pair 1, pair 2, pair 6, 101, this sort of thing. What this issue flow chart is here is each of these is a hyperlink. We'll look at this in a moment. Is this patent valid? And there's a number of issues you look at for that. One of the issues is whether or not the prior art teaches each and every element of the claim arranged as in the claims, and that's a question we ask after we find out what the prior art is, and we answer that question by first finding out whether the prior art is pre-AIA or AIA. If it's an AIA patent that we're studying, we come down through this set of flow. If it's an AIA, then you come down here and do the AIA search dates. So that's green means go yes, means go this way, red means go this way. So under the pre-AIA, you would flow through this. You'd have to figure out what the day of invention is for 102A claims and E claims, and then if you have to find out the earliest constructive reduction to practice, which of course would be the filing date, until you can prove if there's an intervening reference that you have to beat, Then you ask, is there a derivation? In other words, is that intervening reference unrelated to our inventor or not? And then you look for actual reduction to practice before the intervening reference. And each of these issues that you flow through for each claim, and then once you've done the A&E dates under the pre-AA, you come down and do the 102B dates, or the statutory bar. And so that's what this flow chart is. It gives it's a design process flow. And the beauty of this is that you run it with your lawyers, and then you vet it, decide whether the flow is correct. You make changes to it if necessary, and then you have a methodology that people agree upon that's going to meet the Pareto analysis, meaning that you're going to find 80% of the issues that come up in a fairly quick and easy period of time. And then of course, you always have to have experts on these reviewing these things to spot those other 20%. But this is a formalized process, and thus we have in-scope and out-of-scope issues. And these, if you will, are the in-scope issues. And it's the supervisory expert lawyer's job to handle the out-of-scope issues and to make sure that what's in scope was done correctly. And so this process flow is the first document in the priority law flow chart. We saw the first question at the top said, is this patent valid? Well, as we know, 35 U.S.C. 282, presumption of validity, and then the defenses defines what, if you will, what is determinative with respect to validity. And we have case law on that. We've for example, improper revival is not it's not a defense in an action involving validity or infringement. And we saw that in Aristocrat. And so we'll see as we go on further in that that we're going to focus on issues that are determinative, that will defeat the patent. Is this patent pre-AIA or AIA? And so this is this section that we use to make sure that we're selecting the correct law. And then we have checklists, 102A checklists. Each of these are clickable links that you can go down and see definitions in case law or MPP or what have you. That's the 102A checklist. Then we have the statutory bar. And of course these, if you click those links above, and with respect to relevant questions, they'll take you down into these documents so the reader can use these as clickable resources. And then of course we have the pre-AI 102E checklist. And we have the flowcharts, the pre-AI 102E flowcharts from the MPEP. You'll notice that we've lettered each of the nodes of each of these nodes that you can come down one of these paths. We've lettered them, and what we'll see in a minute in a table where not only do we put the effective 102E date for a prior art reference if it has one, but we also put what node we ended up in to find that date, and that verifies to the supervisor lawyer that we know what we're doing in terms of traversing these flowcharts. Then you have other priority law statutes that are relevant for the priority law course. That's what this document is here. Forgive me for going through this quickly. Then we have these data records. What these are is when we have a family of a target family that we're studying, we determine the filing date of the target application, then its parent, then its grandparent, the publication dates, issue dates, where we have support for claims in the family and earlier filed family members, and who is the if it's a author. In other words, this is not a it's not a provisional, non-provisional PCT, but it's open art literature. Then it would have an author. It would have an inventor. You'll see in examples, but we identify the inventor as A, B, C, that sort of thing in these examples, and that's useful for determining a number of issues such as commonly owned, like under 102A, whether or not in the inventions by another, that sort of thing. So we capture the data, we put it in these tables, and we represent our, if you will, our search of the file, and we're providing that information in these data structures to the lawyer to let them know when the ownership, assignment, authorship, where the support is for each of the issued, canceled, or claims. And then this IL, invalidating language, that is if it's a reference family. If it's a reference family, I mean, let's say maybe you have a child application that has the invalidating language you need, but it's not early enough in time under 102E, and it claims priority to an earlier filed application. If it has support, as we know, and it meets the requirements under 102E, then you can get back to this filing date under 102E. And in fact, even earlier ones, as far back as you can have, as you have support, you can get back under 102E, and we'll talk about that too. But these data structures assemble information both about the reference family and also the target of study. And this is the metadata that describes what each of those fields mean. Yeah, like we talked, author, inventor, source. Source of information will be relevant. We'll see under, for example, the AIA when it asks about exceptions, whether reference in, for example, whether content in a patent document is sourced from someone other than one of the inventors. Maybe if it's sourced from an inventor of the application of study, then it may not be prior art. We see in the exceptions. Okay, and then there's these tables. I mentioned that the under 102E, there's like a little spot we put in for pointing out where in the flowchart we ended up. So if we had what our date would go here, and then in this little notch here, we would put what spot in the table in the 102E flowcharts for pre-AIA. And then you'll see that we also have flowcharts made for AIA as we get down here. And that would go for AIA 102A1 and 102A2. There's also little notches you put in letters to show where you ended up in the table. This is the invalidity table, basically yes or no. And what that means is, for example, the 897 as a reference, whether or not it is early enough in time to invalidate claim 1 of the 303. If so, we would put the Y here. And that's what these tables do. They're forcing the reader to understand that that each claim may or may not have the content in the reference. In other words, 897 may or may not have the subject matter to validate claim 1. It may or may not have the subject matter to validate claim 2, and it may not have the subject matter to validate claim 3. Someone new, it's teaching them that it's a claim by claim analysis, and that the content has to be there, and then the date has to be early enough in time. And so that's really that's the gist of what the priority law course is about. Then we have a cheat sheet here. I won't go into it too much, but it's sort of a quick way that you can tell how to set the dates for search dates and effectiveness dates of references. You kind of need to study this, and we do in the course, but I'm not going to try to do that now. Here's the commonly owned flowchart. So if you'll notice, it asks, is this application being treated under the AIA or pre-AIA? If it's pre-AIA, we go down this flowchart, and we either pop out and we're prior art, or we pop out and we're not prior art because we're commonly owned or we're part of this joint research agreement. And this side is the one you go down if the application is being treated under the AIA. And then each of these boxes here you see will have a clickable link in it. And if you're trying to remember what the details are, you can click that and it'll take you down. Each of these Q1, Q2, you can see here Q1, Q2. This is the either the statutory or the MPEP or 37 CFR basis for each of those decisions you need to make. And the main ideas are taken from those resources and put into this flowchart, so you can read them here. But you can also click, if you want to read more detail, you can click into the MPEP or whatever source we got it from. I'll have to pause here and get that back. Okay, and here's the AIA 102 flowchart. determine whether or not the reference is treated under the AIA. If it is treated under the AIA, we come here. We set the shield date for each claim in the target. The shield date is the date, the farthest back that claim can defend a prior art attack. Under the AIA, it's the earliest effective filing date. Of course, under the pre-AIA, we had date of invention, which may be a constructive reduction to practice, or it may be an actual reduction to practice, or the conception date if that's possible, and the details of how to make those determinations are included in the course. But here we're looking at the earliest effective filing date. Once we've set the date for each claim, what the search date is, which, in some 70 to 80% of the cases, it's just the day the patent application was filed. If it's a single application family, you just look for support for the claim, and if the support is there, then it's the filing date of the application. You can't go back to invention date under the AIA. And once you've set those dates, then you come over, you do your search, and then you find a prior reference under 102A1 of the AIA that was accessible before that earliest effective filing date. Once you've found that, then you can ask the exceptions. There's 2 exceptions of A1 references. The first is the inventor sourced prior art less than or equal than a year before the earliest effective filing date. That means if the information came into the public domain less than a year before, and it was sourced by the inventor either directly or indirectly, then to the extent and scope of that disclosure, it's not prior art during the 1 year period before the earliest effective filing date. And of course, intervening, the second one here is intervening after inventor sourced less than or equal to a year before the earliest effective filing date. So what's that? That's the example where the inventor does source it within that 1 year before the earliest effective filing date, and then some other party publishes a document containing that information. And because the information was first published by the author, or forgive me, the inventor of the application in question, this exception tells us that it's not prior art because it was sourced before that intervening reference. You'll notice this YMT. If you have a reference that it's accessible for the earliest effective filing date, then you come down here. If it's not, for example, I don't want to go into too much detail here, but for example, if you have a reference that has, maybe there's 5 claims you're studying in your target patent, and there's disclosure for 3 of them, but not for 2 of them, and so there's 5. The 2 that don't have the disclosure would come down here and be a Y in the chart. Remember those little dots I told you to be letters that would go next to dates? There would be no date, and then the letter Y would be in one where the invalidating language is not present in the reference. But if the invalidating language is present and it's accessible for the earliest effective filing date, then you come down, and if one of these exceptions apply, then the first exception would be an M in the table, the second would be the T, and then the supervisory lawyer can look down and see that you found exceptions and where in the table you ended up, and they can tell whether you're following the flow of these exceptions correctly. If neither of these exceptions come because they don't apply under the facts, then you pop out the bottom and you're a Y. A 102A reference that is a valid prior reference is a U, is a U letter in the table. And then, of course, I won't go down the right side of this, but this is the A2 prior art, and its 3 exceptions. And so that's the flow chart we developed for 102. And each of these questions are clickable to go down and read about the exceptions. You can go down here and read them, and they have links in the statutory basis for each. So I mentioned that during the priority law course that in order to develop those documents and so that the reader, the student understands what they mean, the lawyer understands what they mean, we develop that by case law, MPP, CFRs, whatever the controlling law is in the area, and we often have supplemental reading. There's about 100 pages of supplemental reading in the priority law course. This is beginning of chapter 5, and so you would, in order to teach what concepts mean, case law is a good way to do that. And so these next 100 pages are supplemental reading to the chapters I'm going to show you above. Let's go up and peek at a few of those chapters. Now, so if you decide to use this book as a resource to teach how to perform this process, you're going to have people coming in that have different levels of experience, and they're going to have to judge themselves whether or not which parts of the book they're going to need to read. And so this chapter, for example, starts with the patent life cycle. It explains decisions that an inside counsel is going to make with respect to filing patent applications and in what jurisdictions and what have you. And it gives an example of an invention, GPS tracking of high-risk resources, and it takes the reader through a number of decisions that need to be made. And it explains the patent life cycle, right to exclude, injunction, secrecy, strict secrecy versus disclosure, grace periods. I think it just goes through and talks about, if you will, the dialogue that patent lawyers use, and what the word, terms mean and how they apply in the life cycle of the patent. Hilmer doctrine, provisional applications, non-provisional, what statutes various concepts reside in, and what the priority law underpinnings, non-provisionals, what elements are required to get a filing date, PCT versus U.S. Provisional, continuations in parts, benefit of the filing date, all these sort of terms that we sort of take for granted after being in the business for a few years, are sort of give a dialogue to maybe some of your newer people that are coming in. You may have technical people you use from time to time to do search work or to make decisions about whether a patent or claim is valid or not, and they need to understand the law behind it in some respects. And this is a way for you to offload that teaching by having them go through this stuff. I'm going to go ahead and scroll to the bottom. Again, this book is a resource if you're going to use to develop invalidity and infringement analysis on a team, whether it's inside counsel, if you're developing a team, or outside, or what have you. Each of these chapters has questions to let you know whether or not the reader has assimilated the information, and you can use those as you like. And so it's covering the main concepts that are in that chapter, the life cycle. Okay, when concepts are introduced, often visuals are provided. Like this is an example of the visualization of the pre-AA 102A. You have a day of invention that you can, if you can get back to it under the law, and the very beginning of that day of invention is part of that day of invention, I suppose. And so prior art would be before that day of invention, before the day of invention. So this is a visualization letting them know, hey, prior art's over here, and it's got to be before the day of invention. And then, of course, infringement. If something does not qualify as prior art, and it's it encompasses each and every one of the claims or infringes, then it infringes. And the timing date is that something that's not prior art that performs the claim language is infringing, and that's what this is showing. There's visuals of the various statutes, and it's a good way for beginners or to think about the law visually. And here's an example of the AIA visualization of 102A1 and A2. Here you have a earliest effective filing date. This application here is the earliest effective filing date. This one claims prior to this grandparent, if you will, and this child claims prior to this parent. And then, what is prior art? It's anything before the earliest effective filing date. That bubble is open, indicating the filing date's not early enough. And also, if J is the inventor J, that's what that means, then the source needs to be not J, and it's immediately prior to the earliest effective filing date, prior art, assuming it teaches what you need and has that date. And I'll just talk about the B1 exception, then we'll move on. If it's J during the first year, J cannot be, if so J writes an article, it can't be prior art to a J application. But more than the year, more than a year, J can invalidate its own work. And so this is just AIA visualizations. Here's the A2 and the exceptions to that. And of course, each chapter again ends with questions. It's worth looking. This is how those data structures are used. You have a non-provisional continuation with this filing, publication, and issue date. It supports claims 1 through 4. No claims canceled and claims 1 through 3 issued. The inventor is C, and it was the ABC took assignment on 2013-11, which is November 2013. Claims priority to a non-provisional continuation. That's what this plus means. That information's in the metadata. And this claims priority to a non-provisional original. And these are the filing dates, who the inventor is. Here you have support for claims 1 and 2. But not 3 and 4. Here you have support for 1 through 4. And so these are real life situations that they have to be able to distinguish that some of these claims have different search dates than other claims. And then this is, if you will, a set of references that were found in the search. Here we have an open art literature. It's not a patent. Here's our author name, Goa. And we have invalidating claims for 1 through 3. And the job is to populate, and then these other references, the 905, the 901, and the 897. And we look to say, is this earliest, effective filing date? Is that an effective 102E reference? Is there a publication date in here that's a 102B that beats any of these dates up here in the target of study? And so that's what gets the analyst or the lawyer, whoever's working on this, to work quickly and populate these tables with dates, and then the supervisory lawyer can determine whether or not the information is populated correctly. Okay, let's move over to the second process that's included in this California package, and that's a spec map course. Okay, this is section 2 of the book, specification chart process course, and it starts with chapter 17. We left off at chapter 16 in the previous, and it introduces the spec map, explains. This time we have the process documents on top, and then we go down and describe how to use them. This process has a sample completed project plan, sample completed specification chart process document, checklist A, the pre-A, B, the 101 checklist, prosecution history checklist, claim construction checklist, and sample comments for spec maps, quality metrics, instructions for specification chart tables. And as you may realize, the documents from the priority law course are going to remain relevant to this process. Although it's called a different process, they're very tightly coupled, as you can imagine. So let's take a peek at a few of these. This is the overall flow chart for the process. You map the best support for each claim from the spec adjacent to that claim language. You note any 112 pair 1 issues for each claim. You note any 112 pair 2 issues. You note any 101 issues for each claim. Note any prosecution history concerns, whether it's argument or amendment estoppel. You set search date, construe meaning for each claim, and then verify quality and submit for internal review. The setting the search date is what you're going to use to go find the references, which is in the next process. As you can see, there's 29 chapters, and we started at 17. So there's 12 chapters added in the spec map course. And then we're at the bottom now, where specification chart process documents. Sample completed project plan, you just have deliverables here, the project plan, specification chart, prosecution history, and PDF, marked up claims, search summary, prior art references, and reference chart. This is a prior project for a invalidity analysis. The reason you know that is it has dates for a reference chart. So it includes a spec map, priority law, and the reference chart. Here's the sample completed specification chart. It has metadata about the application, the abstract title. It has claim search dates. It has inventor information. It has family tree, examiner's reason for allowance, issues that weren't able to be dealt with. Here they're saying, look, we need a translated Japanese application, verify they haven't added new matter when they domesticated it in the US. And then you have the claim language, the spec support, and comments about any issues spotted. We use a color coding here, red to red, green to green, blue to blue. It's saying this is the part of the spec, if you will, that's supporting this part of the claim language. And it saves the lawyer a little bit of time from doing that hunting to see where the spec support is. And then on the right here, you issue spot any issues that you saw. Here we have an issue spot. It says the specification does not describe how the global positioning information is translated into the on-the-ground street being traveled, nor the algorithm for storing and retrieving this information on a real-time basis. This means for functional language monitors the transport route of the vehicle based on the measured position does not appear to be properly supported by the specification because there's no disclosure of an algorithm implementing the functional language. So that's an issue you definitely want to spot in a means claim. And so that's an example spec chart. In this case, the supervisor or lawyer only asks for claim 1 to be mapped. They may ask for all the claims to be mapped. That's a negotiation between the lawyer performing the process. Here you have a sample diagram, and then you have the specification process document. And this is telling you what the inputs are. The patent number, outputs are project plan, spec map, prosecution history, and marked up claims. Here's the documents that you use in the process: specification chart, issue checklist 112, pair 1, pair 2, 101, flow chart, claim construction checklist, prosecution history checklist, blank specification chart template, example completed specification chart table, instructions. That teaches how to populate the metadata, and quality metrics. And so these are the process documents. And they're all here. It's an example, it's a real life process that you can run. And it goes on quite a bit actually. So I'll quickly pause. Each of these checklists is 5 to 6, 7 pages long and just covers the case law concepts of, explicit versus inherent. Obviousness is not enough for support. Just various high-level concepts that they need to understand. The 112B checklist and the concepts they need to understand. And these are developed in the chapters. Each of these elements are talked about in case law or questions in the chapters. Here's the 101 checklist, patent eligible subject matter. It also refers to the flow charts. A very dynamic area of the law, as you know, so we're putting a link through to because the USPTO comes up with new directions every other month, it seems like. And the flow chart, then the prosecution history checklist. You're looking for estoppel, whether it's argument or amendment estoppel, or other issues that may come up. And forgive me, we're already at 39 minutes, but I just wanted to give you an idea of what this process is. Claim construction, of course, you have to determine what the claims mean, and we generally recommend going broad with that early in our search until we get a markman. And then sample comments that you can put in the right side column, if you have an explicit support problem, an inherency issue, an obviousness issue with respect to the written description. These are sample comments or the main types of issues that you might expect to come up in an analysis. Then there's quality metrics, where the table fields is the blank specification chart populated according to the specification chart table instructions. Was the search date for each claim properly set under pre-AIA or AIA law based upon the collected evidence? And so you go through as a supervisory lawyer and you rate the work. These are the instructions for the metadata. It tells them where to go get things, what to put in. And so it's a defined process. And all the case law and the reading materials that makes them understand what's there is all included in this. And then we invite you to join and enjoy this course.